Is it on? Okay. Welcome to the Tuesday, May 21st, 2013 meeting of the Hot Springs Board of Directors. Tonight, our invocation will be led by Ms. Sue Hall and to be followed by the Pledge of Allegiance. Would you please stand with me?
Our Heavenly Father, I want to lift up our Mayor, Ruth Carney, and the board members to you. Guide them in all the decisions that you are having them make here tonight. Give them wisdom and knowledge to make the correct decisions for our beautiful city, and cause them to come into unity as we move forward for the future. Decisions they will make for the best interest of our city. And Father, we want to remember the people in Moore, Oklahoma, who are facing such devastation and loss of life. Comfort them and give them a peace that passeth all understanding. Give them a hope to carry on, and bring leaders who will move them in the direction they need to go for rebuilding. In Jesus' name we pray. Amen.
Amen.
I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
I hereby call this meeting to order. Would you please call the roll?
Yes. Davidson.
Here.
Jones.
Here.
Clark.
Here.
McCabe.
Here.
Garcia.
Here.
Foley.
Here.
Carney.
Here. And at that point right there where I said here, I am so glad I'm here. I spent like 8 days in the hospital, and I want to thank everybody who sent cards, letters, flowers, food. It has been awesome to know that a city is out there that are praying for me, and I just want to thank you that I am here. And I want to thank John Webb for keeping me incarcerated until he could figure something out. The staff at St. Joe and the doctors were just awesome. I was kind of a difficult patient, they said. So thank you for your prayers. Thank all of you who sent beautiful flowers, and I just am so appreciative. I'm just full of gratitude. Thank you so much. All right, I guess we'll do business now.
Amen.
The first item of business is to consider the approval of the agenda. Are there any corrections, additions, deletions, or modifications to the agenda, including anything to be removed from the consent agenda? Okay, hearing none. May I have a motion to approve the agenda as presented?
I so move.
Is there a motion to second?
Second.
Okay, all in favor, please indicate by saying aye.
Aye.
Any opposed? Motion is adopted. The next item of business is to consider the approval of the minutes for the May 7th, 2013 board meeting. Are there any corrections, additions, deletions, or modifications to the minutes? Hearing none, may I please have a motion to adopt?
May I so move?
Okay, is there a second?
Second.
All in favor, please say aye.
Aye.
Any opposed? Motion is adopted. Thank you. In an effort to afford everyone an equal and orderly opportunity to address the items on tonight's agenda, I want to remind our citizens and guests that we adhere to a 3-minute limit on your comments. And for your convenience, we will display the clock in the monitors above, and we have a beeper also that Lance makes work very well.
Yes.
Thank you. And out of respect for all of us, we ask that you honor this request. While members of the board may have questions of the speakers, I ask that any general comments that you have to make would be reserved for the board discussion after the speakers have all been heard. We also ask that all cell phones be silenced and during the meeting, and please refrain from any disruptions of the meeting. And should you need to leave prior to the conclusion of the meeting, if your issue is over with and you have to leave, we ask that you do so quietly without talking with your neighbors, because we have to continue with our business. And we appreciate your interest in the business of our city. Thank you so much for being here. At this time, we want to recognize guests, and I don't have anyone written down here as a special guest. Any of you have special guests tonight that didn't get listed? Okay, but we will consider all of you our special guests, and we thank you for coming. We'll now hear our city manager's report, and he got somehow stranded, they say, in another city in an airplane. Anyway, they're paying his hotel and keeping him overnight, and we're missing Mr. Watkins because of weather issues. So we have Bill Burrough to give us a report.
Thank you, Mayor. I'll be brief. Just a few items to mention. First, we had a pivotal vote last week, and we want to thank everyone that turned out and voted, whether you were for or against the issue. We appreciate the fact that you took the time to get out and go to the polls. Secondly, I'd like to mention Adam Roberts, who's been a steward within the city, especially for the environment, the director of our Hot Spring Garland County Beautification Commission. His last day will be June 13th, and he had his reception, or I guess his going away party today, and we want to wish Adam well on his next endeavors and thank him for all the things that he's done for not only Hot Springs but Garland County as a whole. He'll be missed. The last item I have is regarding some of our guys down at our wastewater plant. They found a class ring from 1989 from a gentleman in Montevideo, Minnesota.
Oh, my goodness.
And they took the time to get in touch with the school, track down the young man that graduated, find an address on him. He's still in that city, and we're able to ship that ring back. So, we appreciate the efforts that those guys did in finding that ring. So
That was amazing.
that was submitted by Sean Davis in our utilities department. So we appreciate all the guys that had an effort in returning that ring to that young man. So
neat.
Wonderful.
that concludes my report. Thank you.
Okay, wow. So I need to read a proclamation on our election results. I guess I can leave that hooked. Proclamation declaring results of election for the submission of the proposition to organize the city of Hot Springs, Arkansas under the aldermanic form of city government. I, Ruth Carney, Mayor of the City of Hot Springs, Arkansas, do hereby proclaim that at this special election held on May 14th, 2013, in the City of Hot Springs, Arkansas, the following votes were cast for the proposition to organize the City of Hot Springs, Arkansas under the aldermanic form of government. For the issue was 242 total votes, and against was 2,722 total votes. This is given this 21st day of May, 2013, signed Ruth Carney, Mayor. So, official results. We are glad to be here, all of us. Yes. Thank you. Okay. Now, do any of our directors have announcements concerning upcoming events? Ms. Garcia, should be you.
Thank you, Mayor. I wanted to invite everyone to a community meeting at Forest Lakes Clubhouse, June 6th, 4:30, and Hot Springs Police Chief David Flory will be the speaker.
Thank you. Mr. McCabe.
Yeah, the weather is ever changing, and when I got home tonight around 5:30, the weather from the west looked very menacing. Perhaps it's dissipated, but I'd like to hear from staff members. We got about 60, 65 people in this room. Should we have to take shelter? What's our procedure and where do we go?
The bathroom.
I am bloody serious. I am very serious because I asked that this meeting be canceled. I asked around 5:30 that this meeting be canceled because of what occurred in Oklahoma and what has occurred elsewhere in the Arkansas, Missouri area when we don't heed weather, the strength of weather. And I think this is inappropriate to meet here tonight. I may prove wrong. We may all go home safely, and hope we do. But the risk manager and me asked the question: where do we go? We got people of all ages. We have people of different ambulatory capabilities, and there's no reason that we should be putting anybody in harm's way.
Should we have an event take place Those that are ambulatory will go downstairs to our planning department and will be in a rear hallway in that downstairs in that facility. Those who are not ambulatory or cannot make the stairs, Lance will escort you to the vault area where we have basically a safe room there.
So the people going to planning will need to go outside?
We'll need to go down the stairs. Out in the lobby, you'll need to go down the stairs, and we'll take you straight to the right and take you into a back quarter.
Which takes them outside.
It does.
Thank you. So you all know where to go.
Thank you. Okay, any other announcements? Yes, ma'am.
Thursday night, our city manager, David Watkins, is speaking about his state of the city address, going from good to great, and it'll be at Low Key Arts on Arbor Street, which is behind the Park Island Market and Cafe. And it starts at 7 p.m.
Any other announcements? Nothing going on in your neighborhood this
No,
week?
but I'm just glad to have you back. You just don't know how glad I am.
I heard she got to take charge last Tuesday
Yes,
with the
but I didn't
agenda
want to
meeting.
be in charge tonight.
Thank you. We're so glad you're here, too.
No, I'm glad you're back.
Thanks. Okay, we need to acknowledge that the financial statements notice for April 2013, the records of the city are on file and open for public inspection at the finance office located on Airport Road, and you are welcome to go by at any time and review those. You're always there available. The next item of business is the consideration of the consent agenda. Items in this section are a routine nature and will be considered as one item of business without discussion. I will now entertain a motion to adopt the consent agenda. Have a motion?
Second.
Okay. I have a motion and a second to adopt. Would you please call the roll?
Yes. Clark,
Aye.
McCabe,
Aye.
Garcia,
Aye.
Foley,
Aye.
Davidson,
Aye.
Jones,
Aye.
Carney.
Aye.
Adopted.
Okay. Did you want to clarify that 700,000 just for anybody that might have looked at it? Or is
yeah,
there no discussion? but I
Sure, yeah,
know
we
that
talked about
was-
at the consent agenda, or at the agenda meeting, but the references to the paving, asphalt, and the milling, that's a combined budget amount. The 700,000 is for milling, paving, and for utility repairs to cuts to the
And the
roadways.
total is 700.
The total is 700.
For both of them. That wasn't real clear on there. Okay, the next item of business is to consider resolution number R13-114. Council, would you please read the resolution by title?
Resolution R13-114, a resolution approving a conditional use for New Choice Group Home at 710 West Grand Avenue. That concludes your reading, Mayor. If you now entertain a motion and a second to adopt and have discussion, if any.
Do I have a motion to adopt?
So move, Mayor.
Is there a second? Is there a second?
Second.
Okay, and discussion. And before Ms. Selman brings us hers, just stand right there. Mr. Albright's going to explain something to us.
This is really for the members of our audience and our public at large. This is a conditional use application, which means that it's coming to the board under a quasi-judicial review process, which is different than most matters that come before the board. Issues concerning zoning requests are legislative in nature, which means that as a legislation branch, they can receive comment, dare I say lobbying, by constituents and people who have an interest in the issue. But when it's a quasi-judicial, they're actually sitting here tonight as a tribunal, as though they were judges of the issue. And so they were instructed not to receive ex parte communication from individuals, whether they're constituents of theirs, whether they're the applicant, whether they're the, anybody who would be interested in the issue. This matter is to be decided on the presentation of the evidence and the testimony and the application of the law tonight. And so if you were rebutted by one of your directors when you tried to speak with them about this matter, please don't take it personally. They were following my direction. And please don't blame me. You can blame the Arkansas Supreme Court for that. What little ex parte information that did occur before this instruction has been disclosed to the other board members, and all of the board members have vowed that they will be able to render their decision based on what they are presented tonight, and that their decision will be fair and impartial.
Okay. Ms. Selman.
Thank you very much. Okay. My presentation will be in two parts. One will be the quick description of what the request from the applicant was, and then a very brief response to some of the statements included in the appeal. You have in your packet a ton of information. You have all of the information that went to the Planning Commission. You have a board action request form prepared for you specifically tonight. You have the information that was provided by the appellant. You have a response from the applicant to the appeal, and you have a variety of other pieces of correspondence that have come to us over the last couple of weeks. So let's go. This is a review regarding whether a residential group living facility is appropriate at the applicant's chosen location, which is 710 West Grand Avenue. It's in an area zone C2, which is general business. The area, in terms of its character, is very mixed. We have a service station, a fast food restaurant, a number of homes. We have offices. We have all kinds of stuff going on there. The structure that is under discussion this evening was built in the early 1900s prior to the adoption of any zoning or other standards by the City of Hot Springs. No new construction that would change the outside of this is proposed. So many of the requirements that typically come to you with a development proposal, and this is in fact a development proposal, will not be in play tonight because this isn't constructing a new building. So there's that. The Hot Springs Zoning Code defines a person with a disability, and the request was for a residential group living facility for those recovering from drug and alcohol problems. The Hot Springs Code defines a person with a disability as having a mental or physical impairment that substantially limits one or more life activities, is a person with a record of having the impairment, or is regarded by others as having the impairment. The Hot Springs Code further goes on to define physical or mental impairment. And it's a long definition, but it does include drug addiction and alcoholism. The Federal Fair Housing Act, in addition, prohibits discrimination against persons with disabilities, and it defines a person with drug addiction or alcoholism as a person with a disability. The Hot Springs Zoning Code doesn't specifically have provisions or standards for a residential group living facility anywhere in the city or in the C2 zone district, as this is. In fact, the code talks about a group dwelling rather than calling it a residential group living facility. Our code is old. It is, in many cases, still celebrating outmoded terminology. And as things change, our definitions typically have not. As an example, although one of the major reasons that people come to Hot Springs from surrounding areas is to shop, our table of uses does not mention that retail is, in fact, an acceptable use anywhere in the city of Hot Springs. So, just to kind of put this in context for you. Okay. When applicants propose new structures, the zoning code applies standards for setbacks, height, and area. The existing structure, because it's been there since 1902, exists as a prior lawful non-conforming structure because the front yard doesn't meet today's zoning standard. The proposed residential group living facility is a use that is considered to be residential in nature. It doesn't have hours of operation. It operates like a home. Okay, the project development plan proposes no signs. It already has access to water and sewer, and no mainline extensions other than for fire safety are proposed. So in summary, with regard to the request itself, Hot Springs Code does not allow considering the nature of any person seeking residential use on any property, including 710 West Grand Avenue. Discrimination against persons with disabilities is unlawful, according to the Federal Fair Housing Act. If this project is approved tonight for conditional use, then the applicant will make application when he is ready to proceed to Hot Springs building official to remodel the existing structure's interior. The Arkansas Fire Prevention Code, Volume 2, charges the building official with enforcement responsibility of all building code regulations. And all requirements, including ADA, will have to be met within this structure at the time that modification is sought. Plans will be provided to the building official, and unless there is compliance with the Arkansas Fire Prevention Code, which is in fact the building code as well, then that project will not proceed inside. So on March 14th, Planning Commission, after advertising, approved a conditional use for a residential group living facility at 710 West Grand. Within 30 days, a decision of Planning Commission can be appealed to the Board of Directors, and in this case, that did happen. And that's why we're here tonight. Notice has been provided to meet the requirements of the Hot Springs Code about your hearing tonight. The property has been posted. There was a notice in the Sentinel Record, and a notice was mailed to all property owners within 200 feet of the property. The appeal that we received focuses on a number of things. It's important to remember that what you're dealing with here tonight, what we are dealing with here tonight, is land use. If someone comes to the city and wants to have a beautician shop in their home, they can do that. They can have one chair. And we deal with them on the land use aspects of what they're doing. Do they have parking for their client, so on and so forth. The city does not look at whether the shop operator has the required licenses. There are other agencies that are responsible for doing that. That's not land use. The city is regulating land use. When Planning Commission reviewed the elements of the proposed conditional use, they found that it demonstrated compliance with the Hot Springs Code, the sections in the zoning code, and also those sections in 1724, which establishes minimum standards for a rooming unit. These are very minimum standards. The area that is adopted as being sufficient in the Hot Springs Code may not at all be what you are comfortable with living in. Yet it is the minimum standard that was established by a prior board. And that is the standard that we must apply to projects that come to us. The appellant made a number of references, some perhaps tongue-in-cheek, regarding the comparison of proposed residence at this use to nuns in a convent. I wish that I could take credit for that creative example. It's not me. It's in the definition in the Hot Springs Code of group dwelling. Fraternities nuns in a convent, they're all in there. And that's just the way it is. The comparison of two group living situations, that which is presented for conditional use approval and that's in the definition, was not intended to be humorous and is not in error, because its purpose is to clarify that the character of the occupants is not what is under discussion, and it is clearly not under Planning Commission's authority to make a decision based upon that. Hot Springs Ordinance number 5811 recognizes that physical or mental impairment, including drug addiction and alcoholism, cannot be used as a standard to make a land use decision. And further, the Federal Fair Housing Act also prohibits discrimination against persons with disabilities. Planning Commission responded to testimony about conflict with surrounding land uses by conditioning its approval on the applicant's constructing a fence around the subject property. There was extensive testimony about panhandling and other criminal activity. Criminal activity is not land use. It's a behavior choice. And any land use approval that may come from Planning Commission or from this board doesn't carry with it the authority to behave in a way that is criminal. You're only looking at land use. The appellant apparently disagrees with the staff report in many, many, many areas, but fails to demonstrate how his disagreement with it is relevant to Planning Commission's decision, or in fact, how it demonstrates that there was an error made in Planning Commission's decision, and that is one of the standards for an appeal, to demonstrate that Planning Commission made an error. One of the things that has been pointed out is that this is a use that is not consistent with the surrounding residential character of the neighborhood. The neighborhood is lovely. It is a vital area. I go to Dairy Queen. I love to go there. My dog loves to go there. Loves the puppy cup. But Dairy Queen is not a residential use. Dairy Queen is a commercial use. There's a drive up. People sit in the parking lot. They eat. They talk. They play music. The Dairy Queen is at least as close to the residential properties around this subject address and doesn't seem to be causing a problem. The Hot Springs Code Section 1724 defines rooming unit and habitable space and does establish those minimum standards. The appellant doesn't like the amount of space that's being assigned per occupant. And as we mentioned earlier, that might not be your choice either, but there is a standard. Planning Commission applied that standard, and they'll have to continue to demonstrate compliance with the building code, with any other standards that exist for access, fire safety, and so forth. One of the statements in the appeal is that the public hearing raised concerns regarding these applicants. The applicants aren't on trial. This is land use. Again, whether you like them or don't like them is not grounds for making a decision. Training, licensing, experience, or funding, none of those are Hot Springs zoning code standards for evaluating a conditional use, and not for this conditional use. The appeal also references a swift and irrational change of zoning decisions. The record reflects that Planning Commission followed the standards and procedures for conditional use application in considering new choices application. While reasonable people can disagree about the meaning of individual statements in the code or in the staff report, It's clear from the record that Planning Commission employed a rational approach to considering and deciding to approve with conditions the new choice residential group living facility. There was an earlier application, it was in 2011, by these applicants at this address. It was denied. It was appealed to the board, and the board upheld that denial by Planning Commission. The appellant states that this is an identical application. Oddly, while the request may be identical, the standards aren't. In 2012, Hot Springs changed several of its definitions and standards to be consistent with the Fair Housing Act. So if you have different standards, a different outcome is not unusual. So this conditional use approval is a difficult one to consider. It is land use. It is not who lives there. It is not who operates it. The staff's recommendation to Planning Commission was to approve the group home because the application materials submitted demonstrate compliance with the Hot Springs zoning code. Planning Commission advertised and held their hearing. They did recommend approval. And your choices tonight are to adopt a resolution upholding, in effect, Planning Commission's decision, although I would remind you, you're hearing this anew, afresh. You can deny it if you find that the standards of the Hot Springs zoning code have not been met, or if you believe there's information that Planning Commission did not consider that is covered by the rules in the Hot Springs zoning code, then you can remand it to them. And that concludes my presentation.
Okay, thank you, Ms. Selman. Would you like to, do you have any questions of her? Anyone?
I do have a question of clarification. There's a constant referral to the fact that you cannot discriminate, and yet I guess the innuendo in that, in the writings and the conversation, is that if you can't discriminate, that means you need to approve it. And discrimination runs both ways. So if you make decisions without regard to discrimination, does that mean that you have discriminated if you find against them?
Your choice is to make your decision based upon the standards in the Hot Springs zoning code.
Okay, thank you.
Would you like to call the next witness?
Mayor, if we'll hear now from the appellant, Jerry Rapan.
I have a document I'd like to present it in the easel. Maybe you'll tell me how to best set this up. You do have this in your packet. Excuse me, I'd like the board to be able to see this, and it is in your packet. And I do ask for clarification that my information that's in the packet be included in the record as new information and be considered for this, rather than have me state every bit of it and have the board subject to hearing what's already being submitted. And I have asked several people for the time to be sure that I could speak over the 3-minute limit, because I am the appellant and I need to be able to make my points. And I certainly will be cognizant of the board's time and try not to duplicate things, and other speakers as well. With that said, good evening, Mayor Carney. It's nice to have you back, and members of the Board of Directors. I want to state publicly that we appreciate your volunteer leadership for the city and the citizens of Hot Springs, and I also believe that your 92% endorsement at the recent special election makes you the most popular city government in Arkansas history. We're here tonight asking you to continue your careful maintenance of our city zoning regulations and to once again deny a conditional use permit application by Mr. Larry Weiss to house 20 recovering alcoholics and drug addicts at 710 West Grand next door to the Dairy Queen restaurant. The majority of you were part of a 7-0 vote denying virtually this same conditional use permit on February 8th of 2012, just over 1 year ago. And though our city has a new manager and 3 newly elected city directors, we believe more than ever that Hot Springs is a great place to live and proud to be here. Last year's vote was never a vote against recovery programs, recovery services, fair housing for persons in recovery, or against people in recovery. These services are needed in every community, and Hot Springs provides excellent programs and must strive to do even better for the good of us all. Well-designed and operated group homes benefit any city, and discrimination against recovering alcoholics and drug addicts is against the law. But zoning laws also can and must allow a city board to make rational decisions when a proposed group housing plan would harm a neighborhood and a community. This was the reason for the denial a year ago, and the reason the board should deny the proposed conditional use tonight. So what are the details of this proposed conditional use that are objectionable for Hot Springs? The building was constructed in 1902 as a firehouse. It was never designed or modified as a residence, except when the applicants previously moved in without proper permits recently and were expelled by the city. The building has no yard, as you heard earlier, no patio or other outdoor space for residential use. The entire outdoor area is paved parking lot. You will see later in more detail that the designated parking is unsafe for pedestrians and for traffic along West Grand Avenue. Yard, green space, fresh air, and sunshine are fundamental for any group housing unit. Medical studies confirm their importance in promoting mental health and physical health, aiding recovery from daily stressors all people experience. So now let's examine the inside of the structure, and that's what I've put before you there as well as in my packet. This home for 20 recovering alcoholics and drug addicts will have one small upstairs bedroom, roughly 15 by 16, to house 8 men in 4 bunk beds. You're darn right we don't think it's good for anybody in those conditions. They would share 12 people on the top floor, 1 toilet, 1 sink, and 1 shower among 12 men on this upper floor. The washer and dryer are in this same bathroom. You have that in your packet, and it's right here. Downstairs, 2 smaller bedrooms would each house 4 men in 2 bunk beds. Since our objection to this latest plan, the applicant submitted even another floor plan with at least 8 changes to the plan reviewed by the planning staff report. But they're not obligated to do anything on that revision. You may have received their revision even before receiving my appeal filed weeks earlier than their revision. Now they have bunks for 22 recovery men. The application by Mr. Weiss fails to meet the city statutory obligations for a scale drawing and a graphic representation in their packet because his drawings leave out important building elements that further restrict usable space. Placing 20 men, impaired or not, in these cramped, flawed housing conditions would make anyone claustrophobic, uncomfortable, and at times confrontational. I know of no other residences with similar concerns that are endorsed and approved by our zoning laws. Not only will the residents be exposed to harsh conditions, but their inadequacies will soon become neighborhood and citywide problems. This inadequate housing will virtually push these men onto the streets at all hours of the day and night. When briefly operated before by Mr. Weiss, you heard earlier the Dairy Queen next door reported incidents of panhandling. Longtime customers said they would not return if such harassment was repeated. I must ask you, what comes after panhandling if this proposal is approved in the months and years down the road? Nearby the proposed site are at least 3 churches, 2 schools, a daycare with another daycare proposed. What interactions will we expect? These groups all patronize the Dairy Queen along with youth sports teams, other children, and families. This Dairy Queen is a proven likely destination for the 20 month-to-month residents, just as before, but not a good mix for an important business, their customers, or our community. Because the proposed group home was built in 1902, it is grandfathered into the city zoning laws. For this reason alone, it is permitted less than the minimum front yard. Only approximately 8 feet to its west is a single-family residence, vacated in these last few weeks. Approval of a group home would seriously limit future utility of that location. I certainly admit that this group home would be virtually abutting my family's backyard, and this fact led us to take a closer look. We had known that it was already rejected 2 times, but we never expected round 3 and round 4 from this proposal. But if you choose to approve this plan tonight, it is all of the larger Hot Springs community that is at risk due to these new and lower housing standards. What will our planners look at for the next application and the application after that? Currently, such recovery programs as Teen Challenge and Quapaw House have well served our recovery community, the court system, and other citizens of Hot Springs. Those facilities have licenses, counselors, drug testing, house rules, job training programs. Other group housing serves additional needs, such as small group therapy. Our city codes do not define recovering alcoholic or drug addict that I find. The applicants certainly don't define it. Nowhere do they promise to exclude anyone, even active users. It appears to us that while these applicants are demanding approval of their group home as fair housing and non-discrimination, they really are asking for discrimination in their favor. Even with their stated purpose to house up to 20 recovery alcoholics and drug addicts, they state, this is nothing more than a living facility for up to 20 residents. They add, to my knowledge, a manager of a rooming house does not need to have training, licensing, or show successful experience. We are then asked as a city now to approve a conditional use for 20 recovering men with no services required. That makes it simply a group home for 20 men with no standards other than the applicants may or may not impose or later enforce. Our city has a definition of group home. Examples are convents, fraternities, and halfway houses. Yet each of these really has standards for admission, behavior, and has regulation by other responsible organizations. Mr. Vice Plan does not fit these examples, and we must note the difference. Our city planning staff project summary does begin with a telling statement. Whether the 20 persons residing at the proposed new choice group home will be nuns within a convent or recovering alcoholics and drug addicts is immaterial to this review. That same report and evaluation has led many of my neighbors and I back to you once again, because these residents will not be nuns in a convent, but they will be mere mortals with unpleasant responses to inadequate housing. Thank you.
Thank you. Have any questions for him? How many minutes was that? 'Cause I'm going to give that. Yes. Yeah.
We'll now hear from Travis Morrissey on behalf of the applicant.
Thank you, ladies and gentlemen. My name's Travis Morrissey. I'm an attorney here in Hot Springs, and I have been asked to represent, and previously was before this board on this roughly same issue. I really don't have that much to add to what Ms. Selman said. She made a very good statement that there's a lot of passion out here, obviously, and there's a lot of concern about what all this is. However, you all are sitting as jurists. Mr. Albright did a very good job explaining that due to a recent Supreme Court case, which was Kings Ranch versus City of Jonesboro, they actually determined the difference between the legislative function that you all normally do, which is passing ordinances more like Congress would. Tonight you're sitting more like a judge would. And all I'm asking is that you listen to what Ms. Selman advised you all about, which is this is a land use issue. That our code, and if you'll look at the staff's report, it's rather clear that this is the closest conditional use is a residential group living facility, which is contained in Table 16-2-152 as a permitted use. I will agree that the definitions, while we wish they were more specific, clearly include a group dwelling. Unfortunately, due to the last Planning Commission action and the last board action, my clients were forced to seek some outside intervention from the Arkansas Fair Housing Commission. A Fair Housing Commission case was opened, a HUD case was opened. To my knowledge, that case is open as of today. It's my understanding from speaking with my clients that if there's a favorable result, a non-discriminatory result, if staff's recommendation is met, that will resolve that case, which certainly saves the City of Hot Springs substantial risk, because the backside story to the City of Jonesboro case, which you may have been advised, is it actually cost the city money by following that passion request of its citizens. So based upon that, and there was a lot of misinformation, I think, last time, and I think Ms. Selman did a great job of laying out this is C2. It's surrounded by C2. This building's been here for a very long period of time. Most of the concerns raised by Mr. Rappan and all the other concerns I've had will be addressed. There's not going to be allowed for crime to persist there. That's what the police force is for. They're not going to be able to put in the number of bathrooms that are required is going to be set by code. The inspectors are going to require that be complied with. Electrical will have to be complied with. Fire protection will have to be complied with. All we're asking is that this conditional use be approved and as recommended by staff. I think it'll resolve a lot of the issues. I commend the city for passing the definition of a protected disabled individual. I think that's a big step forward for us. I think clearly under the applicable housing and urban development rules, as well as ours now, a recovering alcoholic and a recovering drug addict is a protected disability. But for that reason, I'd ask that you approve our request and allow this conditional use.
Thank you, sir.
Are there any questions that y'all would have for me?
Questions for him?
Yeah, I have a question.
Yes.
What would be a no vote that would not be discriminatory?
I don't believe there could be one, because if you have staff telling you the applicable rule and you're sitting as a judge, and I understand there's a lot of people out here who want it to be ruled on, but a judge is an impartial arbiter who applies the facts to the law. We have the law, we have a determination of what a group residential living facility is. Ours meets that requirement. So for you all to not approve that, I'm not trying to lecture y'all, but would be per se, if we go to court, summary judgment material. I mean, you have a definition, you have a factual application that meets that definition. To ignore that, it wouldn't necessarily have to be discriminatory, it would just be arbitrary and capricious.
I have a question.
Go ahead. Yeah.
The referenced fair housing action against the city that you referenced, that's in a prior case, has really nothing to do with this. Is that correct?
Well, again, I always say
insinuation that it does, but it really is not. It's two separate issues, right?
not exactly. I mean, this is hearsay, but I've spoken to Ms. Carol Johnson. I believe they're monitoring this case tonight and will make a decision, even though it's based upon a prior application. You'd be correct, Director Foley, but it's the same underlying facts. The only thing that I guess the clarification we made is that we're talking about recovering alcoholics, recovering drug addicts, which puts them squarely within a protected class of individuals.
So does that mean if we vote no on this, that we have two actions against us by the Fair Housing Authority?
My guess is they would consider it part and parcel of the same action because it's the same address and the same complainant, even though it was two different board actions.
Okay. Can I ask for a point of clarification on in the conditional uses? The opening statement for the standards for conditional use, it says that the Planning Commission, I realize that's not us, but we're their proxy right now, I guess, may approve, deny, defer, or modify a conditional use request based on findings of fact with regard to the standards set forth below. There is no discretion in that statement. I mean, no discretionary ability for the Planning Commission in that statement. It says the appropriateness of these standards shall be determined at the discretion of the Planning Commission for each specific conditional use location. So in that statement, it says while we have standards, the Commission has discretion in how they are applied.
I would probably couch it a little bit different, and only because of the recent Supreme Court precedent is in an ordinary rezoning or a non-conditional use, that would be the legislative function where you say, we agree that you're subject to a particular land use requirement, but we can vote as a body to allow you latitude not to comply with that. Whereas when, at least my contention would be, is you're sitting as a quasi-judicial, you're applying a pre-existing law definition, that you're without discretion to amend that within this context. And I think as Ms. Selman, I could understand, she would probably prefer that some of this zoning code be brought up to date to clarify some of these gray area ones, but it would certainly be my contention that in the quasi-judicial setting that y'all are in, you're having to apply what the written ordinances are of the City of Hot Springs.
Right, with discretion in how we interpret them, is that correct?
Well, I would argue
Point of contention?
no, only because a judge sitting over in Garland County Circuit Court has no discretion. He may totally disagree with the definition of manslaughter that the General Assembly came up with. However, that's the separation of powers. He must duly, the definition and the case law that supports that definition, he must apply rigidly. If he doesn't, the remedy is appeal.
Okay, thank you.
Mr. Morrissey, how help me understand then if everything is so clear, then how does our U.S. Supreme Court have 5-4 decisions?
Well, I didn't say it was 100%. Now, again, differing minds. What I would say, Director McCabe, is that in the current situation, we have a pretty black and white definition. We have a group living facility with a lot of discussion about who's living there, the nature of them, if they're panhandlers, if they're criminals, if they're drug addicts, if they're recovering alcoholics. The application is being made for a group living facility that accommodates recovering alcoholics, recovering drug addicts. I guess my statement would be is if any reviewing court looked at it and they said, okay, every physical land use requirement requested by the applicant is met, and then you all deny it, it per se has to be based upon a discriminatory animus, because that's the only other remaining characteristic of this application.
I don't agree with that.
Yes, you may.
Now, I understand if a decision is made based on because someone has a disability, that would be discrimination. If there are other factors that are to be reviewed or other standards that has nothing to do with that in determining land use, that's appropriate.
And I understand what you're saying, Director Garcia, but I guess assuming you all trust your staff, which they're great staff, they've gone through and analyzed every relevant element of the land use request and determined that the application materially complies. So I guess my statement would be if the board found something that was not a required land use requirement, that denial would be per se arbitrary and capricious, because our code establishes what elements you must have to comply. And staff's analyzed all of those for all of you and determined material compliance in all regard. And that's why their ultimate conclusion is do approve this. Because all the other issues, health, safety, welfare, all those that are accomplished by inspections, by sewer, water, sanitation, police, any of those issues are handled not through land use, but through other functions, if you will.
Well, in one of the sections that was presented to the Planning Commission, it did state that the square footage standard was met, but in the section to consider the size and shape of the site, the size, shape, an arrangement of the structure in keeping with intent of the code was disregarded, saying, well, it should be grandfathered in. But it's my understanding when you come forward with another request for a conditional use or a zoning change, that it's appropriate to allow the Planning Commission to consider that when they're considering their conditions that they may want to. And it appears that that was not included.
And if I understand the question, what I would say in the relevant reason disregarded is if they had made a proposal to add on an exterior feature to the physical structure, or they had proposed to demolish part of the exterior physical structure. What they're asking to do is consonant with a zoning level of C2 as a conditional use. If they just said we want 20 people to be able to live there, the reason it's disregarded is because it would probably be disregarded even if we had just a regular blank pad, because if it's within C2 and they said we want to build a 2,700 square foot brand new building, now you'd have some other issues. You'd have landscaping, you'd have setbacks, you'd have some of those things that would kick in, but you would still have the land use being consistent with that conditional use, which was done by a board before this board.
But it is possible that it could impact the conditions that would be considered.
Could I just insert here, over and over and over in our board action request, the statement is made, standards for granting such a conditional use are met according to the Hot Springs Code. Kathy repeatedly answered that through our board. So evidently, if that's true, all the standards have been met for the conditional use.
That's correct, and I hate to say it, but this is an easy decision because it's, you've got, if there was any of those things present, then certainly you would have something to hang your hat on to say something's missing. We don't have everything we should, but instead, staff has analyzed it and said it meets all the requirements, and accordingly in their summary, they recommend that you passed it because the application materials submitted demonstrate compliance with the Hot Springs zoning code. And that's where you look at the Arkansas Fair Housing Commission, you look at HUD, the only thing that can result is that it has you can have a discriminatory animus, an intent to discriminate, and you can have a discriminatory result, which not that you all had an intent to, but the practical effect of your decision was that there was a resultant discrimination. It's still discrimination, even though there was no intent by any director to do that.
Ms. Selman, would you like to address that one more time about, is there any loophole that you missed or did not investigate in that use, land use? Yes, you may. Thank you.
Loophole.
Well, I just read it where you said the standards for granting such a conditional use are met according to the Hot Springs Code, and that's repeated consistently through your report.
Yes. And a thorough analysis was completed, and that is the conclusion of the facts that came out of that analysis, that the requirements are met. And the fact that there is no modification proposed outside the existing building does change things somewhat.
Thank you. Do you have a question for her?
Well, I was going to ask her about, in the packet that went to the Planning Commission, it did say that not to consider that section about considering the setback and the space and the size and shape because of the age of the building. But wouldn't it still been to make everything covered perfectly clear with the Planning Commission to allow them to ask them to waive that, or not just tell them we don't have to worry about that because of the age of the building? So that would have been in the record that they did accept that or waive it, so they had that opportunity.
Planning Commission does have the opportunity to disagree with their staff, and I believe we have many well-known examples of that occurring. The staff report is one thing that the Planning Commission considers in making a decision such as this. They hold a hearing, they hear testimony, they receive written correspondence, they visit the site, they take a look at things and, as you do, apply their own litmus tests. Does this make sense to me? And so that is going to occur, whether the staff tells them that the sky is pink or the sky is green. They have the ability to make that determination based on their own knowledge and experience and using the standards that are adopted by the City of Hot Springs.
Thank you.
Thank you.
Thank you. Okay, before we get started we have a long list of people to speak.
Could we ask Mr. Rappan to come back forward?
Yeah.
Mr. Rappan, you've heard both from Ms. Salmon and the applicant's counsel regarding the application meeting the standards of the Hot Springs Code. What say you?
Well, I say two things about it. First of all, that the zoning code says to consider the impacts on the neighborhood. If you look at the planning staff report, the planning staff report urges approval of the plan, even at the same breath as saying that they haven't examined or impacts on the neighborhood and that there may be impacts presented at the commission hearing. So when I spoke and Dairy Queen spoke and other residents spoke, we indicated impacts on the neighborhood that were never even mentioned. That's one thing. Another thing is the documents themselves that are supposed to be drawn to specific standards and to scale are not drawn and not appropriate to scale. If you look at your drawings, you'll see as other speakers come up and as the screens roll and the documents roll, you'll find that those are not even accurate diagrams and accurate representations of what is there in the property. In fact, the applicant was supposed to do a scale drawing of the adjoining properties. You don't see adjoining properties and you don't see scale, and the revised document that was presented by the applicant does at least clearly say not drawn to scale. We disagreed over that when we were at the Planning Commission hearing. Certainly, this body has discretion to make decisions that are in the best interest of the City of Hot Springs. I do not agree that you are strictly limited to rubber stamping what the planning staff director says is an appropriate condition and must be approved.
So you differ with the applicant's counsel that a no decision could be made without being discriminatory?
I absolutely disagree with that. No, impact on neighborhood, you cannot make a decision based upon a discriminatory reason. There are numerous considerations in approving a conditional use other than whether there is a suspect class or individuals that are discriminated against. To say that that's the only thing that you would have considered defies my thinking or possibility.
Mr. Rappan, if this were a vacant lot, no structure there, would you object to this application for this particular use?
I really haven't considered that. I can't tell you. I think that having 20 individuals in this type of facility is the basis. Are you talking about coming up with a project like this after it's done? That's the question. Anything that comes up with a proposal and a final resolution like this, I find offensive, and I find bad for the neighborhood, bad for the community, bad for the individuals that would live there.
Okay, and again, my question is, if it's a vacant lot and there's no building, what is your objection to this use?
To this facility right here that's proposed?
If it's a vacant lot, what is your objection?
I don't object to a vacant lot. I'm not here objecting to a vacant lot, if I understand your question. I'm objecting to a building that is a two-story building that's about
takes up about 3/4 of a 75 by 100-foot lot.
But see, that's not the issue. The issue is the use for that location. What is your objection to the use for that location?
My objection to the use of that location is that it brings too many people together in standards that are not appropriate for citizens of Hot Springs.
Again, a vacant lot, Mr. Rappan. Don't consider the building.
They'd probably be better living in a vacant lot than they would be living in this facility, Mr. Albright.
We need to refrain from.
Thank you.
I just have one question, maybe two. I read all of this, all the summaries, all of the discussion. We have the packet, the complete packet. The thing that concerns me is, well, have you ever, or do you now have a family member or a close friend that has ever suffered from addiction?
Absolutely, yes. But I don't...
And my question is, would you consider them a panhandler?
No, when someone panhandles, then they are a panhandler. I didn't say that because of every person that suffers those addictions. Absolutely not. They can be sweet people and they can have problems, and many of them are. I don't mean to cast any aspersions because of the history and the actual facts that occurred in this case.
Well, that word came up over and over and over about panhandling and directly related to the people who would live there. And you also, I'll just read from the staff report in city. It says the staff report in city zone code nowhere defines recovering alcoholics and drug addicts. Community safety should be required some definition for monitoring and limitation. The potential for abuse and harmful community impact is clear and present danger. So in your own words, I would like for you to define what a recovering alcoholic or a drug addict is in your definition.
That's not my role. That's a document that you're going to live with. I don't know.
I'm asking in your own mind, in your definition, in your own words, what would you consider a recovering alcoholic or drug addict?
A recovering alcoholic or drug addict, in my mind, would be someone who is struggling with addiction and trying to get free from addiction. Recovering is a wide range of people, from people that are really suffering and struggling and low down the pole and maybe even a danger to themselves and a danger to others, approaching death. They can be recovering and they're working towards it very unsuccessfully. Recovering can be someone who slips up occasionally, who takes from the lowest pain pills to the highest narcotic drugs that we have in our hospitals or anywhere. And it can be someone who is 3 years clean and sober, who is still recovering and needs to be reminded day after day that they're thankful for the sobriety that they have and the benefits they can give to their community as a result.
I know, and so there's really no limit. There's no qualification for drug addicts. I know a fifth grade teacher in the city that's a drug addict. I know very wealthy businessmen and women that are drug addicts. The number one, according to the Center of Disease Control and Prevention, the number one epidemic now is prescription drug abuse, and that's legal. And you mentioned over and over.
No,
about
illegal use is not. I mean, some are legal and some are illegal,
right,
and many
but if
are
the doctor keeps giving it and they've become addicted, they're addicted.
Serious problem.
And you have mentioned that since illegal drug use is obviously a crime, the risk.
I don't think you're reading from my report even.
I am. And
may I see a copy of that? Because I don't know what.
It was in the packet. So anyway, all I'm saying is.
Tell me what page that is, and let me get the copy.
Helen writes number 3.
Page 173 of the packet.
173 of the packet. So over and over.
I don't have a 173.
It seems that you're profiling who these people are without even knowing who's going to be in there, and that seems to be dominant through here.
I question that that's my writing at all without seeing it and being refreshed. I'm sorry. It doesn't sound like language I used.
The staff's response to that was Appeal D3. appellant in direct conflict with his opening assertions that admittedly this appeal is not due to occupancy by any particular group or class of persons protected by our laws from discriminatory efforts, makes several contradictory, unsupported, and outrageous statements. That was the rebuttal to that one. So all I'm saying is it seems to be like we're profiling whoever might live in that building or a new one, to the extent that we really don't know who these people are, or what their background is, or how wealthy they are, or if they just can't make it at home and they have to have a safe place to live to be Kim-free. My instructions on this, it will be a Kim-free house. So it's probably one of the safest houses in that area because you don't have to get a permit to cook meth in the other ones. This one would probably be one of the safer places in the community to protect people.
Mayor, I'm not certain if you will have the right to give such directions. Once you approve this, I don't know what authority you will have to control that. And I would like to respond that I did not use the term panhandling repeatedly through my 6 pages of appeal. I referred to that along with many other issues, but it's certainly not the one issue that we relied on.
You said that it would be a breeding ground for illness, disease, and crime. You made a lot of statements, and panhandling was mentioned several times. All I'm trying to say is if we are being discriminatory, it's those people we're talking about that aren't even identified. That's all I'm trying to say. It's that it can be your grandmother that's an addict. You know, it can be your aunt or your uncle. We're clumping all these people in that one house and giving them a label, and labeling is not fair. It's just not fair. So this is a land use issue, land use only. Land use. We're not even going to the codes on proper room size or toilet. You know, that'll come later if they decide to go ahead and remodel. But this is land use only. It has nothing to do with my best friend who is an addict right now.
It's housing for 20 recovering alcoholics and drug addicts, Your Honor. 8 of them will stay in one small bedroom, and 12 will share, and it doesn't matter.
And that's not the issue tonight. Tonight's issue is land use only. Land use, not who's going to be there.
It could be anyone that could be there, and it would be inappropriate, in my opinion. And that is my point, that it's inappropriate for anyone to be housed there.
Okay. Thank you. Okay, we have lots of people signed up to this. And let me just read this before we get started. As earlier stated, we have 3-minute limit on your comments. If someone has already covered the point that you want to cover, please consider whether or not you have something to add to the discussion. If it's a new item, please do not repeat over and over the same issue. We want everyone to have the opportunity to be heard. However, let's try not to duplicate the points that have already been made. And thank you for your cooperation in this regard. And do remember that we are talking tonight not about the structure and the codes, but we are talking about land use only in this area, in this neighborhood. So let's keep that kind of focused, what the issue is.
Excuse me, Madam Mayor.
Yes.
Is the applicant, Larry Weiss, going to speak tonight?
Yes.
Okay, thank you.
Let me see, how far down? Everybody signed up. Let's have Jerry Wagner. Would you like to speak first? Or Larry? Jerry Wagner is... I don't see Larry Weiss. He's not signed up.
My name's Jerry Wagner. I kind of had something prepared here, but most of it's been covered here tonight. But I do want you to know that my wife and I have owned Rainbow Realty at 710 West Grand for over 30 years. We constantly noticed panhandling in the Dairy Queen parking lot. Occasionally, these panhandlers came into our office. Not long after my wife, Irma Poole, retired, my wife and I quit going to Dairy Queen as we no longer felt safe. We witnessed drug deals in the parking lot continually. The police had to be called on a regular basis due to drugs, knife fights, people with guns, etc. Most of our 31 agents were afraid to go to Dairy Queen. 710 West Grand is surrounded on all sides by properties zoned C2. Rainbow Realty sold their executive office, a commercial building at 712 West Grand. The new owners moved their mother in there. I understand she no longer lives there. It is a commercial building. Mr. Weiss is employed by Garland County Juvenile Drug Court as a crisis and intervention officer. He is a member of Garland County Juvenile Drug Court. Prior employment includes 27 years in the real estate business. His qualifications are more than enough for him to manage a group living facility. A manager of a group facility does not require licensing, and there is no need to prove he has adequate funding. City Code 4-10-1, transit merchants, includes an ordinance prohibiting panhandling in the city limits. Panhandling is not a criminal offense, as Mr. Rappan would like you to believe. There is not even a statute against panhandling. We do not condone or encourage panhandling. However, it still exists by homeless individuals. We have an opportunity to help some of our young people from joining the homeless by working their way into becoming an asset for our community. 710 West Grand will be brought up to code and will be operated as a first-class rooming house. Mr. Rappan would like you to believe 710 West Grand, and I paraphrase, will be a crowded, substandard housing that will be a breeding ground for illness, disease, and crime. He would also like you to believe this rooming house, and again I paraphrase, would become claustrophobic, hostile, and confrontational. I spent 34 months aboard ships in the Navy. Our living quarters were approximately 16 feet by 16 feet. Approximately 32 sailors slept in one room. The crowded housing did not create illness, disease, or crime. We did not have grass, patio, and yet we survived without becoming claustrophobic, hostile, or confrontational. We did not commit crimes, nor did we panhandle. Mr. Rappan would also like the board to believe that the residents of New Choice will have a harmful community impact and would be a clear and present danger as they have the potential for criminal activities. I submit everyone has the potential for criminal activities, including attorneys and the good people who live on Quapaw who do not seem to worry about drug users and drug dealers in their residential neighborhood, and yet are afraid of sober living residents in a commercial district.
Thank you, sir. Your time. Okay, Judy Ladd.
Hi, I have no problem with having drug addicts or recovering alcoholics in that area. I do have a problem with that building because from the size of that floor plan, it's the size of my house. And I've got 2 bedrooms, 1 bath, and I have guests that have spent the night. And trust me, in the morning, it's a Chinese fire drill to use the bathroom. Now, you want to put 20 people or 12 people in that much space with 1 bathroom, you're going to have men who have to go to work, have a real problem using the facilities and getting fed and catch the bus on time. When you look at our animal control buildings, those dogs have a minimum space that they're allowed that you can put dogs in. We have nothing here that says humans have that same right. These people are going to be crowded like, what, puppy mills? I don't know what else to call it. How can you expect people who are in recovery, who've already got their egos smashed to the ground, to feel like they're wanted and responsible and cared for if they're treated like sardines in a can? It's just unrealistic, and it's unfair to them, and it's abusive. I think you will find yourself in a serious situation when somebody gets hurt or something happens to them because they are so cramped and they have to get to a bus and they have no way to do it because the facilities do not accommodate them. Thank you.
Thank you, ma'am. Okay, Greg Gardner.
Hey, everybody. I lived at Larry's place in 2011 for about a year, and it's a good thing. It's a positive thing, and the guys, they're good guys, and I just came up here to support them.
Thank you, sir. Appreciate that. Okay, Barbara Spindler.
Sorry. I'm going to take that time off getting out of the chair. Hi, I'm Barbara Spindler. I live at 640 Quapaw, and I want to thank you for letting me speak. I'm not going to speak on the entire speech I prepared because it's already been covered. But first, I am a registered nurse. I trained in Philadelphia. I am certified in inpatient obstetrics, and I also have a bachelor's degree in healthcare administration. On that basis, I think I have a little bit of knowledge I can share with you. First off, I dealt with pregnant women for 45 years. Dealt with patients who were addicted, did have alcohol problems, did have drug problems. So I was on the end of caring for them, even though it was in the hospital. I am bothered by the plan, I really am. But my big thing about this, you talk about land use. The lot that the building is on. Stimulation plays a great role in an attic. And you push too many buttons, that client tries to get away from it. Where is the client going to go? It's just not a good situation. And what happens, this is my question to you guys. Okay, you approve for the land use. What recourse do we as Hot Springs citizens if the building is not brought up to the code it should be? Do we have any recourse? And that is my concern. And my big thing the last time was plan of care. You'll find in your packet there's an 8-page document that came from Little Rock. I cannot divulge where it is. It was given to me anonymously, so I cannot tell where it came from. 5 pages of that 8-page document are rules and regulations which demonstrate plan of care. The client reviews it, signs it, and if they twist one little finger the wrong way, they are asked to leave. And that's all I have to say. Thank you.
Thank you. A.J. Wagner.
Madam Mayor, can I ask a question? And this is really for Kathy. Based on Ms. Spindler's concern regarding the code, if the building is not brought up to code, I realize that the building is not the issue. This is a use of land issue. But she does have a separate question that I think I'd like to see addressed, and that is, what is the mechanism for the citizenry to notify the city that buildings are not up to code to ensure that there is safety in the neighborhood?
If that occurs, a call to the planning department will result in an inspector or a building official visiting the site to assure that there is compliance with health and safety rules.
Okay, thank you.
Okay. Ms. Wagner.
Thank you.
I'll be relatively brief. I would like to clear up something. There's a awful lot of misinformation about the building. And there's a lot of misinformation about how many people will be in the rooms. There are 4 different areas provided for them other than their bedrooms. There are currently 3 bathrooms in there, not 1. We were putting fencing, Larry is, because I'm not in it, putting fencing up around the building. There will be a patio area in the back where would be parking, because right now Larry has one. He has 8 people in. It's a 2-bedroom. And one person has a car other than him. Most of these people do not have vehicles. So parking will not be a problem. Noise will not be a problem. Mr. Rappan states this application was substandard. He also alleges the group home would be substandard and degrading to the occupants. I think the ones that are living with Larry now tell you differently. These young people cannot afford a fine home like Mr. Rappan's. This group home will be the first step in a series of steps that these young people need to become responsible adults. The plans for 710 have been submitted and researched by architect David French. His preliminary research of 710 West Grand will meet all city codes before it opens. Not only will this group housing be brought up to code, but it will be a quality home for young adults to live in while they seek jobs and re-enter society. One of the biggest things for 710 West Grand is the fact that it's on a bus line. These individuals can go to the mall, they can go to the show, they can go to the court, they can go to walking distance to almost any religion is right there. And I believe this group home will be an asset to our community and will provide a positive impact on the neighborhood. There were a lot of other things that could go in a commercial building that probably would not be what the neighbors wanted. And I feel that this group home, of course, Jerry and I feel very strongly about this. We're on the Drug Awareness Committee with the Elks. We've been to all the schools talking to our young people. We're trying very hard to save the young people from getting into it. And we would also like to save the ones that did. Because there's no telling if you get one person saved, how that ripple will affect the other people. Thank you very much for your consideration.
Marcia Blackwelder.
Oh.
Thank you. Would you state your name and your address? Are you the video man tonight?
Here you go, Bill.
Yeah.
Are you the video man?
Where's Leslie?
Okay. Marcia Blackwelder, 701 Prospect. Most of us have been touched in some way by the ravages of alcohol and drug abuse, whether it be a friend, a family member, a neighbor, or a co-worker. Rehabilitation and redemption are important elements of our society. Had this proposed project at 710 West Grand Avenue been for 7 or 8 individuals in recovery, we would not be here tonight having this discussion. But instead, we have the racking, packing, and stacking of 20 men being warehoused in a small house with no outside recreation area, and 8 men in one room and 12 men sharing one bathroom on the second story. Surely there are better options and ones that preserve a modicum of privacy, dignity, and respect. These are the aspects of the proposed project that does a disservice to the city, the proposed residents, and the neighborhood at large. If you're going to base your decision on on a complaint filed with the FHA based on discrimination and non-compliance with the FHA, should your decision to approve or deny be based on FHA compliance for all of the project and not just some of it? The fact that this project is for the disabled, a reasonable expectation would be a submittal for a proposed project for the disabled. Although not required by the city at this point in time, it is ADA FHA compliance, which will dictate the actual number of residents to approve a proposal of up to 20 disabled residents at this time is speculation. Under a CUP, the city is charged with regulating off-street parking. This becomes important due to the lack of on-street parking. The 4 parking spaces to the front of the property encroach, infringe, and block the sidewalk, whether it be a small, mid-sized car or full-size vehicle. A full-size truck vehicle encroaches, infringes, and blocks not only the city sidewalk, but most of the city easement. This pushes pedestrians out quite near West Grand Avenue, Highway 7270, and impedes pedestrian access as well as denies wheelchair accessibility. All four spaces back out onto West Grand, Highway 7270. The staff report, page 4 of 7, F states, the internal street system ingress and egress, off-street parking, loading, and pedestrian ways will be efficient and safe. The use of these substandard parking spaces to the front that encroach, infringe on the pedestrian ways is obviously not safe nor efficient and denies pedestrian and wheelchair access to the public. To the back or rear, unless you have a fleet of Mini Coopers or subcompact cars, the backing out radius is compromised and inadequate due to the location of the back porch and 3 AC heating units which all protrude into the back parking area. As currently configured, 4 of the back parking spaces will be impacted to a large degree, making some spaces impossible to back out of, and all will experience some difficulty backing out in an attempt to avoid hitting the porch and units. However, I do not doubt the fact that reconfigured, there are 6 parking spaces as required by the city, and possibly more. The exact number is unknown at this time. According to the staff report A, proposed use is so designed, located, and proposed to be operated that the public health, safety, and welfare will be protected. Based on what I have discussed, photographic submittal and site development plan, findings A and F of the staff report cannot be asserted or affirmed as presented. I would ask that you deny the CUP based on noncompliance with the findings A and F. Thank you very much.
Thank you. Drew Cook.
Good evening. My name is Drew Cook. I was born in Hot Springs, grew up here. My folks live in the Quapaw district. They're at 111 Pecan. Ken Cook's back there support me. I work with Larry New Choice thing. I'm the housing coordinator. Of course, we have policies. Of course, we make people be sober. We didn't include any of that in the application because it's not relevant as a matter of law. There's all kinds of interesting things we could talk about, but they don't apply here. I will say, you know, I'm glad I came tonight because I thought people just didn't want us around. It's good to know they're just worried about how comfortable we'll be. That's certainly comforting to know. I'm going to be living there. I won't be running it from an office downtown, so I'll be there with the other folks. I used to be an IT executive for Honda in Ohio, and I didn't fail out. I decided I wanted to do something that meant more to me. You know what I mean? Because I had a problem with alcohol abuse. I don't have a history of panhandling or hanging out in parking lots, but I did drink an awful lot and nearly drank myself to death. And I thought being part of something like this might be rewarding to me, you know. And I believe in Larry, you know, so I'm doing this for free. Not because I'm naive or because I need somebody to help me figure out how to be comfortable or go into a rage, because I think this is worth doing. You know, our objective really is to empower individuals to make better choices for themselves, their families, and yes, the community. You know, this is a community service ultimately, you know, because people get their self-respect back, you know, kids get their fathers back, you know, mothers get their sons back. We turn criminals into taxpayers. That's what we're trying to do here, people. It's a good thing. And the other fellow's right, you know, you don't need a permit to cook meth. And, you know, we live in a city. We have problems that all cities have. That stuff's everywhere. You know, isn't it better to try to work on the side of the angels here? And as has been pointed out, this complies with the code. You know, I'm reminded of the old gag where somebody gets told not to think of a pink elephant, and then all you can think of is a pink elephant. You know, I respectfully ask that if you guys hear, and I'm not saying you do hear, but if you happen to hear the unworded request that this noble civic endeavor happen close to somebody else's yard, that you disregard it and uphold the laws of this nation, please. Thank you for your time.
Thank you, Mr. Cook. Cynthia Falk.
Bring that down a little bit. Honorable Mayor and Board of Directors, good evening. My name is Cynthia Falk. My home and business is located at 1011 West Grand Avenue. I own See the Difference, located on West Grand Avenue along the business corridor, which features insurance, real estate, dental clinics, law offices, a church, and the Area Agency on Aging. We are doing everything that we can to build our business and help West Grand Avenue remain a stable and a viable part of our inner city, and we welcome you to come by and visit us. We do not ever want to discriminate against any persons with disabilities, and we're not asking that the city discriminate against these men. We are asking that the city establish a policy to accommodate group homes and address the high volume, habitability, and safety of this project. We cannot assume that all the proposed residents, 20 recovering alcoholics and drug users, will all be persons of good behavior all the time and confine all of their activities to their premises. Of course, they should be free to go anywhere at any time and do whatever they want to do. But some of the places that they will go may have adverse effects on our business area. We are asking you to please give considerations to all of our businesses and provide some regulations for this property use. We look forward to seeing you soon, and we thank you very much for listening to us tonight. May God bless each and every one of you, and thank you for serving and caring about our city. Thank you.
Tom Harris.
My name is Dr. Tom Harris, and I'm the owner and operator of Summit Dental, about a quarter of a mile on Central Avenue from the proposed halfway house. And I was going to go into a diatribe, but I'm not going to repeat some of the things that have been repeated. Unfortunately, y'all are in a bad situation. You've got a neighborhood with a lot of probably friends and people that want you to determine one thing, but it's quite clear that y'all represent the city of Hot Springs and all the citizens of Hot Springs and a fiduciary duty to uphold the law. Unfortunately, you're facing a Fair Housing Act lawsuit, apparently, that we're all looking at, that y'all are looking at if you vote negative on this proposal. And I believe that's the pink elephant that was talked about earlier and everything. I am a recovering drug addict. I own and operate a business that now has about 15 employees, and we do about $300,000 of payroll for the city of Hot Springs. If I didn't have a group home or a free chemical-free living opportunity, I might not be here today. So thank you for your time.
Thank you so much, Mr. Harris. Glenn Duncan.
Good evening to you all. Thanks for giving us the opportunity to speak. I am Glenn Duncan, and my wife and I live on Quapaw, right directly behind Dairy Queen and the fire station. In fact, our property is within 200 feet of the fire station. Our home is part of the Quapaw Prospect Historic District that is on the National Register of Historic Places. By and large, our district is a very quiet residential neighborhood, and with very few rental properties and I can't read. Commercial activity between West Grand and Hawthorne. We are not asking for the board, city planning staff, and planning commission to discriminate against the recovering alcoholics and drug users. We only ask that you consider the negative effect of this application with its extreme high density occupancy plan in this building. Nothing was communicated or submitted with this application to mitigate any potential impact on adjoining properties. The applicant has only stated in a public letter that it is his intent to house 20 male recovering alcoholics and drug addicts. He says he was going to put up a fence on portions of the property. However, he may choose not to construct it if he so desires. The privacy fence should be 8 feet high and on all 3 sides of the property. And I urge you to please make this screening fence one of the requirements of occupancy if you do determine to go with this. We strongly urge the board of directors and planning staff and commissioners to consider a policy for the city that will address all such group homes and include requiring reasonable safety and occupancy conditions. This would serve our area's interests as well as those of the entire city, and for the applicant as well. Whatever you decide tonight will impact the future of all neighborhoods, both commercial and residential throughout this city. Thank you for your time and consideration on this project.
Thank you.
Thank you very much.
Mr. George Pritchett.
George Pritchett, 210 Carl Drive. I can assure you I worked in that building for a period of time for the Wagners at Rainbow Realty before we moved. Panhandling was alive and well then, and I won't go up there after dark. But that building is empty, and I won't go up there after dark. These are our brothers, folks, and they may have an addiction. This is a temporary facility for them. They're trying to process through there, move out into our community, and be productive citizens. This family that wants to do this is giving a tremendous amount back to the community. I understand the neighborhood and some concerns, but they've demonstrated with other facilities that Larry's been in. And Larry, I asked him a few minutes ago, I said, Larry, what are you? I said, are you a recovering addict? And he said, yes. I said, will you be that till the day you die? And he said, yes, I will. And that's what I believe a recovering addict is. It's going to be someone that does that. It's touched all of our families. I have a family in my family that has 11 children. They all lived in 900 square feet with one bathroom and all grew up there, and none of them have gone to jail, but a few of them have been addicts. The parking there, you do back out, but the parking will be in the back. These people that are going there don't have cars. They're people that need to be on the bus line. They need to be on the services. And folks, if you just turn to your east of there and you go down there and you go down at night, because I play pool at 3Bs on a pool league. Let me tell you what, I don't want to be traipsing around over to the courthouse parking lot down there that direction at night either. So, but I've been panhandled in Hot Springs in front of the Arlington Hotel, and I've been panhandled in front of the convention center too. So panhandling, it's just alive and well. I do trust Ms. Selman and the things that she does and how her department works, that they're going to make sure that this facility meets all of the requirements, all of the legal requirements. I just think that we need to have more of these facilities. If you look into that neighborhood, we have homes right now for abused women and shelters. Now, I'm not going to give you the addresses because I don't want to expose people. This is very much in the public, but those homes are scattered throughout. So are sex offenders. So are ex-convicts. So are drug users. If we locked every drug user up from 6 o'clock until midnight tonight that used drugs in Hot Springs, Arkansas, we'd have to take them to the convention center. And speaking of crowded conditions, we are getting a new jail, but this is much more space for every one of them than exists in our jail today. I urge you to approve this, not because it's best for the neighborhood, but it's the right thing to do. These are people that we're trying to make productive citizens out of. Thank you.
Thank you, George. Rhonda Harris.
Good evening. Hang on, I'm short. My name is Rhonda Harris, 708 West Grand. I'm here tonight representing my family. We are the owners and operators of the Dairy Queen of Hot Springs located at 708 West Grand. For more than 60 years, our restaurant has served the people of Hot Springs and surrounding areas. Dairy Queen is one of the largest fast food organizations in the world with more than 6,000 restaurants in the U.S., Canada, and 18 other countries. Our Dairy Queen is the place you'll find customers, visitors of all ages. I know some of this has been said. Sports teams, business people on their lunch break, families taking time out to enjoy great food and ice cream. And each week we host many church groups, senior citizens, and birthday celebrations. We've always been committed to serving Hot Springs, your grandparents, your parents, your children, and your grandchildren. We are proud and honored to have our Hot Springs Dairy Queen featured, that picture, nationwide on posters and murals throughout all the Dairy Queen locations. Our Dairy Queen is an icon for our city, and we would like to continue our business. We keep our property in good, clean condition, and we try to be good neighbors and corporate citizens of Hot Springs. We do not want to discriminate against any persons with any disabilities. We are proud to be ADA accessible. We really have no idea what this proposed group house with 20 residents will be like. All we know is it has been represented as a group home for up to 20 males recovering from alcohol and drug addiction. We know nothing else. Only time will tell for all of us. Naturally, there is considerable uncertainty on our part as to the future of our business with this very high-density residential group housing up to 20 males. Will they respect our property and all of our customers and visitors? We don't know. If we had a clearer picture and assurance of what regulations would apply to the tenants from the city and to whom we might depend upon, and if and when there are problems created, it would help immensely. This Dairy Queen means a lot to us. There's 4 generations. We had hoped to keep this business in operation for years to come at this location. This business quarter of Hot Springs is undergoing revitalization, which has given us much hope and encouragement. And I think Jerry said earlier, there is a proposed daycare center going directly across the street from us at Dairy Queen. Again, I want to state that we are not asking the city to discriminate against anyone, handicapped individuals, anyone. Thank you for letting me share our concerns tonight.
Thank you. Mark Faulkner. Did they leave? Mark Faulkner. Curtis Larson.
Good evening, Your Honor, board members. Mr. Albright said you were the judges and jury tonight. Well, Your Honors, my name is Curtis Larson. I live at 868 Quapaw. 7 years ago, my wife and I moved to Hot Springs. After retiring at 58, we made our list, checked it twice, and traveled hither and yon throughout the South looking for our new home. Every time the list was cut and it was shortened, Hot Springs was still there. In the end, the Spa City beat out Beaufort, South Carolina, Venice, Florida, and my hometown, New Iberia, Louisiana. We had only one wish every place we visited, and that was a place that controlled architecture with no willy-nilly expansion, and we thought we'd found it here. We visited the village in Red Oak Ridge and liked what we saw, but it seemed to be lacking history and character. Nothing against those places, but we visited the Quapaw and I knew I was doomed. Being married to a woman who's convinced she was born in the wrong century, I knew we'd found a home. And anyone who's married knows the mantra, if mama ain't happy, ain't nobody happy. So there we are. The only problem were the rules that the controlled access residences had that the Quapaw did not. Then it dawned on me what we had learned throughout our travels in the South. I recall something someone said to me about a historic district and said, the developers don't control this because they're long gone. This is a jewel for the city, and it's controlled by the city council and the planning commission. They're responsible. Protection, however, is not altruistic. It is based on tax revenue. And anything that hurts the Quapaw hurts tax revenue, which is the mother's milk and lifeblood of any city. And for that reason, I ask you to reject the proposal for the group living facility. Protect our neighborhood. Thank you.
Thank you, sir. I guess if Mark Faulkner is gone, Mary went with him. Was Mary Faulkner here? She's gone too? Okay. Cynthia Kahili.
Madam Mayor and members of the board, my name is Cynthia Kahili and I reside at 900 Prospect. It is a special treat to be before you and see all of you again, and my best wishes to you, Ruth, for a speedy recovery. Most of all, we recognize the need for facilities in Hot Springs. I think all of us here tonight and throughout our city, we want the facilities that are needed. We want to help the disabled, including the recovering alcoholics and those with drug addiction. We do not want to exclude or discriminate against any person with disabilities. The Fair Housing Act states, and I want to make sure that the board understands this if you haven't read it, that communities may set occupancy limits, space requirements, and other restrictions on housing that is occupied by unrelated people like a group home, if the same is applied to others in the area. If our city attorney, Brian, feels that this issue must be granted due to a Fair Housing Act and the city's current ordinance, I strongly recommend the following: that our city board of directors develop and implement a common policy for group homes so that both the providers and the neighborhoods will have a better understanding of the requirements. Right now, we have nothing, and that's why we're all here on separate sides tonight. I would like to ask some questions about this matter. Is this permit irrevocable or revocable if any conditions accompany the permit are not met? Brian, can you answer that?
The permit would be conditioned upon them complying with whatever conditions were, so it wouldn't go into effect until the conditions were met, if that answers your question.
Okay, and the second question, is this permit transferable from this owner or tenant to another owner or tenant without a review from the city?
It runs with the land.
My concern has to do with the loss of value to the adjacent properties. If this permit is issued without any conditions, there will certainly be a decrease in the value of those adjacent properties, in particular the residences. I believe that the addition of certain conditions to this permit may well protect the values of all of our properties. I think it would be appropriate to send this application back to the Planning Commission with specific directions to consider reasonable, rational conditions that would benefit the neighborhood and may well be a benefit to the applicant in the long run. The number of residents per bedroom should be limited and completely ADA accessible. The building should have fire suppression system as prescribed. Installation of private fences should be in place with no exterior lighting or sound equipment that would intrude on the properties. The owner should be required to have some responsibility on the occupant's behavior. Which should meet all codes, but not limited to building, fire, housing, and zoning. If you proceed to dismiss this appeal, you will have an unconditional conditional use permit that goes against all reason. Thank you. We need quality group houses to help our recovering addicts. Thank you.
Thank you.
Madam Mayor, excuse me.
Yes.
Ms. Kahili, could you repeat your last sentence, please?
We need quality group housing.
Sorry about that, Cynthia. You got me in a double negative, I think.
Okay, let me see if I can remember it. I may have made it up. Okay, we need quality group homes to help the recovering addicts.
Thank you.
The sentence right before that about...
Okay. If you proceed tonight to dismiss the appeal, you will have unconditional conditional use permit, and this goes against all reason. Is that it?
Back up one more. No.
Yeah, one more time.
Okay.
Please.
The facility should meet all codes, including but not limited to the building, fire, housing, and zoning codes prior to occupancy.
Yes, and I
Is that
think
it?
that's been covered already by the next step that Kathy was, it's in our BARF. That's not what the issue is now. They cannot even do this until that's all approved. She went over that with us. You want to clarify that, Ms. Selman? That's the second step.
Yes, that if this is approved, then yes, any modification to the inside, and in fact, any certificate of occupancy would be contingent upon the meeting of all applicable codes. With regard to conditions, Planning Commission did establish a condition for fencing on 3 sides. I'm taking liberties here with my time, if that's okay, did mention that the applicant could, if he so desired, not do the fence. Planning Commission certainly didn't indicate that, and if you're considering approval, I would urge you to restate that condition for a fence on 3 sides, and I think Ms. Kahili's comment about exterior lighting or sound equipment being prohibited might be something that you would wish to consider as a condition also. These clearly are land use type impacts, which can be handled by you without sending it back to Planning Commission. You're hearing this anew. We're not hearing anything new about the use that Planning Commission didn't consider. But if suggestions for mitigation are raised, as they have been tonight, those are certainly things that you can consider tonight.
So would you state that very clearly so I understand? You're saying that if
you yes, go ahead.
You say it again the way you
Okay. If you want to have a fence on 3 sides, as Planning Commission did, please restate you want to have a fence on 3 sides.
Okay.
If you wish to prohibit exterior lighting, you may do that. If you wish to prohibit exterior sound equipment, you may do that. Those are things that relate to impacts that are clearly options for you to consider.
Okay, when you say eliminate exterior lighting, are you saying no porch lights or no parking lot light?
I think that would
getting technical.
Be unreasonable. But if you wanted to regulate the light in such a fashion that you had fully downcast lighting that does not impact on adjacent properties, there's no leakage, as you would say, from if you're standing on your property and the light is next door, you are not affected by it, the light is contained on the property. That kind of thing is something that you certainly can consider to mitigate any impact that you see here.
Kathy, do you know if the Dairy Queen has light that's all downward?
I don't know that.
Thank you.
Mm-hmm.
It's pretty well lit. The parking lot is.
What
good.
other conditions can be considered?
Those are the type of conditions that are being considered. Typically, in considering conditions, you're trying to solve a problem that you've already identified. And so outside conditions, in this case, have been raised in testimony, along with a suggestion for how those could be addressed.
Yes, ma'am.
Well, are there more speakers?
Yes, there are.
Okay.
This was just a explain to us what you mean thing. Okay, Dave Reagan.
Madam Mayor, others who have spoken against this issue quite eloquently have covered the points that I was going to cover. In the interest of time and avoiding redundancy, I will recuse.
Thank you. Okay, I have a name that I'm not sure about the last name, but it's Nick. That's you? Okay. You'll just state your name when you come up.
My name is Nick Esparza, and I live at 539 Prospect Avenue.
Okay.
And I am not totally against people getting drug treatment and receiving help, but the whole idea that it's just about land use and land use only seems to be that you guys are going here and here with the whole land use thing, because you can't talk about land use without talking about the effects of the overall community of land use. So if I have a home and I'm putting 20 people in a 3-bedroom home with 3 bathrooms, not one of you up here, Madam Mayor, and you, I'm trying to read, but you as the attorney, not one of you would put this many people in your home and have them live there. And as somebody who's gone through drug treatment and been recovering from substance abuse for over 20 years, it seems to be a little bit ridiculous to assume that we're going to put somebody that has no experience running a drug and alcohol house. We have no licensed mental health counselors working with these people. And part of it is the relapse aspect of it, that you have to have trained people to do their job. Now, the other answer to the city attorney was to Mr. Jerry Rappan was that if it was a vacant lot, would one be opposed to it? I think the answer is, under this plan, yes, we would be opposed to it because it's a poor plan. It doesn't take into account the aspect of the overall community, and it doesn't take into account public safety to the community. And you as the city attorney and you as the mayor have an obligation under the police power to provide us with public safety. And the aspect of panhandling that you keep talking about is really has been a little bit overplayed. I've read the documents that Jerry has talked about. I don't think that it's all about the panhandling part of it. It's about the public safety part of it. And we're not against people receiving treatment, but this is a bad plan for us and for the city of Hot Springs. Thank you very much for your time.
Thank you. Okay, Bill Drews.
Madam Mayor, honorable directors, I appreciate you letting me be heard tonight. First, my name is Bill Drews. I live at 254 Ramble Street. I have a small statement of anonymity that I would like to read. There may be some here among you who are not familiar with our traditional personal anonymity at the media level. The public relations policy for Alcoholics Anonymous is based on attraction rather than promotion. We need always maintain personal anonymity at the level of press, radio, and films. Therefore, we respectfully ask that no AA member be identified by full name or photograph and published or broadcast reports for this meeting. That being said, I am a recovered alcoholic. I've been sober for 32 years. I'm going to speak from experience of halfway houses. I moved here 17 years ago from San Diego, California, where I was on the board of directors for a recovery home called The Way Back. Now, there are a number of recovery houses, halfway houses, group homes in the San Diego area. Each and every one of them met with the same, I hate to use this term, but I don't know any other one, NIMBY attitude that I've heard here tonight. Not in my backyard. And anyone who doesn't understand what NIMBY means. Now, with very little research, you can find that halfway houses, group homes, whatever, are very good neighbors. They always become good neighbors. Now, that being said, everybody that's in recovery is certainly not cash register honest. But the program teaches honesty, and those who practice the program of recovery learn to become honest, and the fact that employers have also discovered that hiring recovered addicts and alcoholics is a smart thing because they're very grateful for a second chance, and they work very hard at being good citizens. And that has been my experience for many years with the program of recovery, both with addicts or addicts, and whether it's alcoholic, drugs, or something else. But recovering addicts and alcoholics are really decent people. Thank you.
Thank you, sir. Marcia Smith.
I'm Marcia Dobbs-Smith. My home is located at 720 Quapaw. And when you think of a home, you're thinking about a place where you feel comfortable, a place that when you say I'm going home, you're saying I'm going to a place where I feel safe. And that's how I feel in my home, and I'm not sure that I would feel comfortable and safe in a home where there were 20 people. I don't, as my namesake said, I don't think we would be here. Most of us wouldn't care at all if this was a home that had 6 or 8 people in it. We regulate how many animals you can have in your home. We regulate how many parking spaces I can have at my business. I'm even told how many bathrooms I can have in my business, and I'm not sure why we cannot regulate without being discriminatory the number of people that can live in a square footage area. Our jail, our brand new jail that we've just built, had requirements for sunlight and recreation areas, and the jailhouse to me sounds like a place with less density than this home will be. I certainly, all of us know and have family members or friends who've had drug problems, and the more family that's involved, the less likely that these people are to repeat. But the statistics show that 90% of people who are alcoholics or drug abusers slip in the first 4 years. And being in an area where I hear both sides saying that we have panhandlers and drug dealers and things in that area, having that many, 20 people in one spot who may influence others, one of the steps of recovery is to separate from people who might cause you to slip. And if you put 7, 6, 5, a few people in a place, the odds are less likely. But if you put 20 crammed into one little space with a 0 lot line and no recreation area, I'm really not sure that there's going to be much success. These are tax dollars that are being used for this. The majority of that money comes from the federal government, but who's the federal government but us? So I'm not sure that that's a good use of our tax dollars either. Thank you.
Thank you. Okay, now it's your turn, board.
Vice going to talk?
No, he didn't sign up. Mr. Vice, would you want to speak? I didn't have your name here, but you are very welcome to come up if you'd like to do so.
No, I'm good. For the sake of several things that it's not. I'm Larry Vice. I'm the director for New Choice, and
Again, just to refer back to the application, that's what I've been advised to do. I don't want to sling anything. All we are doing, and have been doing it since August of 2010, started with nothing, and there's several lives that have been put back together. Now, what really probably bothers me the most was when this initially started. And yes, I did. I had some misunderstandings in reference to the building. So there were 6 of us, including myself. Now, what I know factually, none of these people were panhandling or ran anybody off. Rhonda and myself have been friends for a good many years, so I thought. Now, I noticed she signed in as Rhonda Harris initially. Last time it was Rhonda Johnson. Now, what I do know is Mr. Buddy Harris is sitting in county right now with weapons, methamphetamine, and burglary charges. So I don't understand that needs help. But I really don't have anything to say other than, appreciate you.
Okay, let's not respond. Would you please, the audience, please be quiet while we've been.
Yes, I haven't said a word while anyone else was saying anything.
Okay.
But thank you very much. Thank you for your time.
Mr. Vice, let me ask you a question. Yes, is there a reason why you need 20 people?
We are a non-profit.
Ladies and gentlemen, really, we're trying to conduct a hearing. This is what this is about. This is what this body is trying to do. Please have respect for the process, if not for the people, at least for the process. Yes, sir.
And let me apologize for my earlier. There's a lot of people out there need some assistance with this, and that's what I focus on. In reference to your question, is there any? No, sir. We were given how we came up with the number. We were donated, I believe it was 11 bump beds, and that's kind of how we, had just, laid them out. 20, no, probably realistically, more than likely what will be consistently going, after my 3 years experience doing this, probably, 16, 17 people would work well with the program that we work right now.
Is there any way that location could operate better with a fewer number of people?
With that location, come again, Brian.
The building.
Yes.
If you had 10 people in that building, can you not operate an efficient program?
Well, certainly we could. I certainly we could, but I'd like to stick with the application.
Thank you, sir.
Thank you.
Okay.
May I ask a question?
Mr. Vice, one more. Yes, ma'am. I think they have a question for you.
Yes, ma'am.
We received in our packet, at least I just received just before as we came in here, something submitted by Marcia Blackwelder. And I think it's as a part of this, there's an attachment that has the example of plan of care management in Little Rock. Are you using this plan of care? Are you familiar with what I'm talking about?
I'm not familiar with it, no, sir.
He doesn't have to.
Right. Okay. Then I apologize. Okay, thank you.
Thank you.
Questions?
No, I would just comment.
All right.
Madam Mayor, there were some photographs that were to have shown that I'm told there was a malfunction and were not. May I take 30 seconds to indicate what those pictures
We've received most all of them in our packet, and I'm sure that all of us have looked through everything. We've read it in detail, so I think our time is running short.
Yes, ma'am.
Yes, ma'am.
We received our packet, and we've received additional information. I've got 2.5 inches worth of research and documents and packet information. The testimony here this evening, I took notes, and from the notes I took, I think everyone here agrees, regardless if you're for or against, that these facilities are good. You heard success stories from people that were brave enough to talk about their situation and how these facilities have helped them. What I've got, that everyone agrees we need more of these facilities in our community to help more people. We did have some things come to light that I would like the board to consider regarding these additional conditions, and I want those to be well written and to have the proper consideration. So I would like to move to remand this to the Planning Commission for consideration of other potential conditions, and not to change the land use approval, but for consideration of the potential conditions.
I second that.
We have a motion and a second. Is there any discussion to this amendment? Is she amending?
Motion to remand.
To remand. To
Can I amend? Can I make a? I don't really want to amend it, but with this remanding back to the Planning Commission, we've received new documentation tonight that I did not have time to read, and that's why I asked Mr. Weiss if this information we got applied to him. He never saw it. So I think in fairness to the applicant and the appellant, this information needs to be shared with them for consideration at the Planning Commission if it gets remanded to them.
I think the information we receive, though, is opinions from other people as to what they should be doing with their program. They have their own program and their own plan.
I don't want to make that judgment. This is new any more than I want to make judgment on anybody that spoke here tonight. This is new information that came, and I have not had a chance to really review it and digest it. And I'm not sure that it's really fair to any of the board members to have to consider that information, because if there is any discussion after the fact, I'm positive that this will come back and say, did you consider it?
Is that land use or program facility?
I have not had a chance to review it and make that decision. That's what I'm saying.
But regarding the motion and second to remand back to the Planning Commission, at that time, anybody that goes to that meeting can present and share information.
Okay,
but
would you like to state it?
We do have a motion and second.
There's a motion and a second on the floor to remand back to the Planning Commission for consideration of other conditions to be placed on this application. Is there any further discussion on the motion to remand?
Yes, ma'am.
Can I add some things?
Are you going to ask to amend her motion to remand?
Well, I have some reasons that I've been writing down, listening, and I have gone back and forth with this decision. And for Mr. Morrissey to say this is an easy decision, it is not. It's not easy for any of us. And if there's a person in here that says they don't know somebody that has dealt with alcohol or drugs, they're lying to you. Whether it's your family, your coworkers, your friends, whomever, we've all experienced that. And if you haven't, it's a blessing indeed. I was going to vote just strictly on land use and say yes, but the more I've thought about it, I have to agree that the plan is terrible. If this had been an application that sometimes I have to review, say, for other situations where you have to review applications, I would have given it a D or a C minus, because it's poorly done, it's poorly written, it's just a bad plan. And there are so many issues that have been brought up tonight that were not taken into consideration in that plan. I have problems with, number one, the location, because it is a zero lot line. Number two, the lot itself, where it is. But secondly, because of the number of people that would be in this group home. And obviously, we don't have a good policy for group homes, and maybe it's time that we constructed one. This might work with 8 people.
Please.
This might work with 8 people or 10. But I think it's a detriment to the individuals to cram 20 in there. That this space might work better with 6, 8, 10. It might work really well. I don't know. But for that, I couldn't approve it as it is. So I would have to agree and concur with Director Garcia that maybe we need to go back and do some fine tuning to it.
Okay, if we're in discussion on the
Motion to remand.
a motion to remand, I am not for that. I think we've had all the information we could ever read presented by the people who have brought this to us for a land use issue. They have not brought this is not their final drawing. This is not to be presented to the codes and the building people. This is not for any other reason. That's just a rough drawing. They did not have to have their plan incomplete to bring to us a reason for land use. It was not required of them to have their complete plan on who is going to counsel and what kind of rehab or what kind of facilities. None of that was required of them. That's why we don't have that information. It was not a requirement for them to ask for a land use. So to send it back over something that we're not even dealing with, I think is just complicating things that have been drug out for a long time. They can't even proceed with their next plans until we allow the land use to be there, and then they have to go through planning department, they have to go through everything, they have to go through codes, they have to do the proper everything later. That's a completely different issue. So to remand it back to have Ms. Selman redo everything she's already done on land use, because she's not even dealing with the issue of occupancy or even how many people can be in there. That is not even the issue tonight. We have one issue: whether or not in this area land use could be that. Then later they'll have to come right back into this room and give us their whole plan, and then we'll have to say, yes, that's too many, or no, that's not enough, or whatever. But that's not what we're dealing with tonight. We're dealing with land use only, not their plan, not their program of rehab, not who will be living in their house with them. We are not dealing with who the people will be in that house. We are dealing with, can that piece of property ever be used for a group living facility? And if it were nuns, would we be even having this or remanding it back to Ms. Selman? No, we would not. We are still discriminating because they're not nuns. I think bottom line is we don't need to prolong something that's just she's already said it's met every requirement the city has. It's too late for us to go revamp the city requirements for this issue. It wouldn't even apply anyway if we revamped all of our rules. We can't change our rules in the midstream. We have to write our ordinances. They have to be approved. They have to be passed. So to remand it back is like redoing everything that's already been done. Okay, who had their hand up first?
For Madam Mayor, thank you. Just for clarification, I wasn't remanding back for changing the land use approval, but to ensure we get the conditions. There were some good conditions and other discussion for consideration to get those documented correctly.
And she said we could do that tonight with the fence. She said that could be done now.
That's why I don't think I want it to be done correctly, and I think it would take time for us to noodle through that tonight to have it done correctly. And I would like the Planning Commission to review that. And it may not ever come back to us. Ideally, both parties will agree at what is, if anything is changed at the Planning Commission level.
Would that have to come back to us if we remand it?
Not unless it's appealed. Yeah. If it's approved, or if it's if it's denied and the applicant doesn't appeal, or if it's approved and property owner doesn't appeal, then that's the end of it. But what Director Garcia is saying, just beat a dead horse here. She's not asking that the land use approval be changed. She's asking that the Planning Department and the Planning Commission consider other conditions to place on the application to try to achieve some of the safeguards that everyone's so concerned about.
External conditions, though, right? It can't be how many people are occupying the place, right, on this or not.
Any mitigating conditions can be addressed. Is that my understanding?
It is, but I do want to. We're talking about the remand motion, but I guess what you're trying to do is talk everybody out of remanding. So let's go ahead and address it. Ms. Kahili mentioned some good things. Okay. looking at what our policies, could be going forward, not discriminating against classes of people or disabilities or family status or any of the sort, and dealing with the numbers of people that can occupy. That is legislative. And yes, that can come back to you at some future date as proposed legislation that you can approve. This, again, is an appellate procedure, quasi-judicial, on an application for conditional use. So we're stuck with what we have before us. We can address it. You can approve it, deny it, or remand it. The motion that's on the floor is to remand it without changing the land use approval, but dealing with permissible conditions on the application. That's the motion on the floor as I understand it, which was seconded.
Okay, we have a motion and a second. Did you have discussion, Mr. McCabe?
Well, I think I understand what Director Garcia is doing. She's just saying that we had received an appeal of the decision by the Planning Commission, and she's asking for the Planning Commission to take into consideration some of this testimony and see if there's not some other conditions that we can place on it. That, and like you said, it may or may not come back to us. I'm looking at this, and I'm fine with that. I'm comfortable with that. But I'm also sitting here as, I don't know, 6 people have probably told me tonight, as a jurist. And I think when Mr. Morrissey made a comment to my question regarding the Supreme Court justices, and they can have a 5-4 decision, that they're entitled to a difference of opinion, and yet in this case the facts are so clear that I just have to say yes, because if I say no, there's no way of saying no without being discriminatory. I'm not sure I accept that. I can accept it at face value. During the time that this is going to be reviewed, if this motion is approved, I'm going to delve into that. And so I'm not going to lay idle on that, because I think it's imperative, at least from where I sit, that I give, regardless whether I wanted to say yes or no, if the roles were reversed and I was required to say no because someone said the rules say no, that I can't possibly say yes because that would be discriminatory towards the other, I would at the same time say, I'm not so certain I can accept that. So regardless of what side, is up on that, I want to make sure that what people are telling me is correct. Kathy does a very good job, but she's not infallible. We've had many reports that had to be corrected or a testimony or something come up later and say, I'm sorry, I mean, we did not apply this. And I'm not just speaking of Kathy. We had it in city utilities. With all the water extensions. Things didn't come back to us in accordance with our rules, but it had been going on for years. And now they're trying to catch up on that. So that's all fine. People make mistakes and there's oversights, but I'm a jurist here now. And so I've got to make certain that what is being told to me is correct. I'm not going to, it's difficult at times to not always be trusting. But now I'm not in a legislative role. I'm in a jurist role. And while I want to be trusting to what people are saying, I want to make certain that that is fact. And so I'm going to spend this time, should it be approved, that to ensure that what was offered here tonight is fact. So thank you.
I still.
Yes, ma'am.
I have a statement. I agree with you totally. It is a vote about land use. It is a vote about land use for 20 people.
Make one comment before you call
As
the
it
roll.
is now.
Before you call the roll.
Any other discussion?
Call for the vote.
Any other discussion on the motion?
Okay.
Before you vote on the motion, this is directed to the board as a whole, and also to the audience and anybody else who may be listening or wants to weigh in on this issue. This is still a quasi-judicial matter. It's going to go back to the Planning Commission on a quasi-judicial matter. Ex parte communication is prohibited. Please do not contact board, please do not contact staff, do not contact commissioners to try to influence their movement on this issue.
Well, let me address that, because I would like to spend some time with Kathy Selman to further understand our city code. So do I have the ability to do that?
You can talk to her about city codes all day long. You can talk to her about possible future legislation, but you cannot talk to her about the merits of this case.
I can't talk to her about how she applied the city code to this case?
Not to this case. You can ask her what her interpretation of the city code is and how she applies it in general, but not to this case.
Okay, so then based on her applying general information to me on how the city code should be applied, I interpret what I think she's saying as I render my decision, and then somebody's going to tell me that I'm discriminatory.
You refer to yourself as a jurist.
That's right.
The Arkansas Supreme Court hears cases that are appealed from the circuit level. They're not permitted to sit in circuit court and listen to the case. They hear it on the record. And if they need further explanation, they remand it back. They don't pick up the phone and say, Judge, well, you really messed this up. This is what you should have decided. They remand it back for further consideration, further hearings, whatever is required at the trial level. You're sending it back to the trial level.
And let's deal with emails and phone calls from the citizens.
No emails, no phone calls. They can't stop you from sending them. If you just insist on sending them, I'm going to ask them to delete them. But if you send them, they're going to print them out and they're going to distribute them to everybody else. If the applicant sends something in, the appellant's going to get it. If the appellant sends something in, the applicant's going to get it. Our goal, fair and impartial. No conflicts. Ex parte communication really should not occur. I'm sorry that that's the way that it is. Our Arkansas Supreme Court has said conditional use applications are quasi-judicial. They are not legislative.
Okay.
I'm sorry. I'm still, so it's up to me to make a decision whether they applied the rules correctly.
Yes. That's
exactly. But then somebody else is going to make a decision that because of the decision I made, I was discriminatory.
Yes.
Even though there was no discrimination involved.
That's the quasi part. You're not the Supreme Court. The difference between you and the justices on the Supreme Court of the United States is they're appointed for life and there is no appeal.
Did everybody get this that he sent to us?
I just have a point of clarification or question based on direct...
One question. Did everybody get the whole print on quasi-judicial and the whole packet that he gave us? We had all that reading material. Okay.
Based on what Director McCabe said, I understood you to say that we have to make a decision based on whether the facts were applied. Are you making the my understanding is that we are looking at this brand new without regard to what the Planning Commission's consideration was, whether they were right or wrong. That's really not what we're trying to do.
What you're trying to do is apply the facts of this particular instance to the law that's currently in effect.
And now we are remanding it to the Planning Commission, at least under the motion, for consideration of putting some things that would take care of mitigating factors in their decision.
Yes.
Okay, thank you.
Yes, sir.
Okay, now would you please state what we're voting on is a yes or a no on a...
You have a motion and a second to remand this back to the Planning Commission, not for a change in the land use issue, but for consideration of conditions that might be placed thereon. A yes vote would remand it back to the Planning Commission without ex parte communication or influence by the board. A no vote, you continue your discussions about the issue tonight.
Okay, would you please call the roll?
Yes. Jones.
Yes.
Clark.
Yes.
McCabe.
Aye.
Garcia.
Aye.
Foley.
Aye.
Davidson.
Aye.
Carney.
No.
6 ayes, 1 no.
All righty.
Pass.
All right. So is that it?
Yeah. This will be worked up by the planning department and put on the next available planning commission
We have
agenda.
One more item on the thing. Do you want to hit it?
Two more.
Two more?
Isn't there? Yeah, there's two more.
Oh, the mechanical code and the,
I was just gonna say.
yes, please do.
I mean,
I hope so too. Thank you.
Yeah.
Would you bring her?
yes, what would you like?
Water.
Scotch?
She said dinner.
Water? Do you care if it's room temperature or you want cold?
Anyone?
I think we had crackers and peanut butter. Shoot, I ain't had this.
Ladies and gentlemen, would you please leave quietly? We still have other issues on the agenda to deal with, and it's getting late. Thank you.
We need to keep us some snacks here. We do. We need some snacks.
Where's your purse? Do you have anything in your purse?
I didn't bring it.
Work at a place where snacks are born.
I didn't bring anything.
Oh, you do have something.
Should just put him in stone there.
Bring anything because I didn't think we was.
Madam Mayor, I have a question. I don't know when is the appropriate time to begin to address some of the residents' concerns about addressing the zoning code relative to group living. I don't know if we do that tonight as a part of the discussion, or we have a planning session to talk about the issue of zoning, or what we do. I don't know what's the appropriate forum to move this forward.
You could have a session. Typically, changes, amendments to your zoning code come to you by way of recommendation from the Planning Commission. But if you wanted to have a work session with the Planning Commission to talk about these issues in general, you know,
I'm not, I mean, I trust the Planning Commission to come up with what they perceive to be appropriate standards for group living here. I just don't know how to get it from here to the Planning Commission as a request for them to come back to this board with something.
I think that's her job.
Okay.
It has been so requested, and we will pass it on.
Thank you, Kathy.
Okay. The next item of business is to consider number O1330. First of all, entertain a motion to suspend the rules and read by title only.
I so move.
Is there a second? I have a motion and a second to suspend the rules and read by title. All in favor, please say aye.
Aye.
Any opposed? Would you please read by
Ordinance 01330, an ordinance amending the mechanical code of the City of Hot Springs, Arkansas, Ordinance 5821, to reinstate certain sections of the Arkansas Mechanical Code 2010 edition, and for other purposes. That concludes your reading, Mayor. If you now entertain a motion second to adopt and have discussion, if any.
Okay, do I have a motion to adopt in a second? And discussion, Ms. Selman.
Thank you very much. This is a request to amend the mechanical code regarding the installation of flex duct.
Okay.
And it's very simple. At this time, there is terminology in the Hot Springs Code that does appear in other city codes in Arkansas, but is more stringent than the state's law on this matter. Hot Springs Code says flex duct shall be used as a connector only, not to exceed 6 feet in length. That replaced language that was in the original Arkansas Mechanical Code 2010 edition, 2 sections. The first one was that flexible air ducts shall not be limited in length. That would be put back in. And the second thing that would be put back in is flexible air connectors shall be limited in length to 14 feet. Now, what we're talking about here is only in attics. It's not in walls, it's not in chases, it's not in crawl spaces. It is only in attics. Right now, you can have 6 feet of flex duct and no more where the ducting connects to a, God, I'm so tired. The little register. Yes, thank you so much. To the register. That is a change that has been brought to the city manager. At least one home builder has stated that the regulation being more stringent than the state's requirement acts as a disincentive to home builders when they're making a decision as to where to build, that they are choosing to build outside the city of Hot Springs. The impact to city funds is non-existent. It is estimated that on an average house, that the decrease in cost to the home builder would be somewhere in the vicinity of $500 per home. And so the recommendation to you is that you adopt this ordinance amending the mechanical code.
Well, the only thing that I would add to Ms. Selman's presentation is, our single-family permit numbers are somewhat anemic in the city, and there is a perception among some of our builders that and without the perception, they don't have that same requirement in the county as we have in the city. And what we are discussing and talking about doing is coming back to what the minimum standards that the state has adopted. We're one of the few cities of size that do have that requirement. And if we are ever going to aggressively pursue residential development within our city, then we have, as a city, have to change the paradigm and look at ways to spur that development. So I did want to add that this is definitely a perception that's out there that they don't have that same requirement in the county, and that's a true perception. So thank you.
I would agree with those comments, and I had looked this up on the Arkansas Mechanical Code and did not realize that when we adopted the other ordinance that we were making it more stringent than the state requirements. And at the 500 cities with the Arkansas Municipal League, there was only a handful that had that, and only 1 or 2 that were comparable.
Mm-hmm.
So I would speak in favor of this ordinance change.
Other comments, questions? Okay, hearing none, would you please call the roll?
Yes. Clark.
Aye.
McCabe.
Aye.
Garcia.
Aye.
Foley.
Aye.
Davidson.
Aye.
Jones.
Aye.
Carney.
Aye.
Adopted.
Okay, passes. Okay, the next item of business is to consider ordinance number 01331. I will entertain a motion to suspend the rules and read by title only. Do I have a motion?
So moved.
Okay, I have a motion and a second to suspend the rules and read by title only. All in favor, please indicate by saying aye.
Aye.
Any opposed? Council, would you please read by title only?
Ordinance 01331, an ordinance authorizing amendments to the budget of the City of Hot Springs, Arkansas for the year 2013 and for other purposes. That concludes the reading, Mayor. If you now entertain a motion, a second to adopt and have discussion, if any.
Do I have a motion to adopt? A second? Is there a second?
Second.
Okay, and discussion. Yeah.
I'm just here.
Yeah, you're just here for Doretha?
Yeah.
Is she still on vacation? Yes. Not fair.
So I understand y'all have already discussed this, so if you don't have any questions, it's okay. But if you have any questions, I'm here.
Okay. Have any questions? Have you all read it in the packet? You understand? Okay.
Explained it.
And you waited all this time. Sorry. Okay, thank you. Okay. No discussion. Would you please call the roll?
Yes. McCabe.
Aye.
Garcia.
Aye.
Foley.
Aye.
Davidson.
Aye.
Jones.
Aye.
Clark.
Aye.
Carney.
Aye.
Adopted.
Okay, it's adopted. That concludes the business section of tonight's meeting. And are there any comments from board members that you would like to express?
I'd just like to say that I'm glad that we sent that back, because when I came in here, I was very confused and I couldn't really voice my opinion. That's what really bothers me when I have to keep my mouth shut. But I'm glad that we sent it back. That it was. Thank you, Director Garcia, for that.
All righty. Any other comments? Everybody all right?
I just have one comment. One of the very frustrating parts of this whole proceeding for me was it seemed like there were a lot of personal attacks on the appellant, and that bothered me. I would hope that when we look at appellants or anybody who gets up and speaks to us, that we respect their position. We may not agree with it, but we really should discipline ourselves to fully respect it without providing opinion that is derogatory. And so that's all I have to say. We ran into that tonight, and I am embarrassed by it, and I hope that it doesn't happen again.
Okay.
You know, just to follow up on that, I think that a lot of that was, quite frankly, caused by all of the extraneous contact that everyone had. I think had the process been followed, you wouldn't have known all of that personal information. There wouldn't have been all of these emails and attacks and that sort of thing. So we'll try to do better in the future, giving y'all more advance notice of things that are even applied for in the Planning Commission, so that you'll know on the front end if it's a conditional use, even at the application level. And I'll get with Kathy to set that up so that you're notified when an application comes in initially for a conditional use application, so you'll know when someone calls you about, 123 Main Street, hey, you know I can't talk about that one.
Okay, thank you.
That might help.
It will.
And if someone does file an appeal, that they're given that information.
Yes.
Or that
Yes.
they've
Well-
got it, that tells them that what this is and that they're not to contact.
Yeah, well, in October, we talked about that. In October, I gave you all a form that was adopted from another community to try to utilize when it's handed out. When you receive an application to fill out for a conditional use application, you would see what the rules are. And so if you'd like to revisit that, I'd be happy to do that. I think that would be very helpful so that the applicant also knows they're not to try to make contact. Because, your email's up, it's going to receive the email. You can't stop it from coming in. So, thank you.
Any other discussion, comments? Okay. Immediately following tonight's business meeting, there will be a public commentary here in the board chambers, and we will do that as soon as we turn off the microphones and turn them back on. And this meeting is adjourned. Oh, do I have to have a motion to adjourn
Can we
the
take
meeting?
a 5-minute break, please?
Can we have a motion to adjourn
So
the
moved,
meeting?
Mayor.
Okay, is there a second?
Second.
All in favor, please say aye.
Have anybody signed up?
Adjourned. Okay, yes, we do, one.